Good afternoon, and welcome to our panel titled DAR by Design, Regulating Manipulation in Online Environments. I am a research associate of the Interdisciplinary Center for Security, Reliability and Trust of the University of Luxembourg. We're carrying out research in the domain of human aspects of privacy. And I'm thrilled to have the opportunity to moderate this superb panel today, which is going to focus on dark patterns. You may have heard of them, but they are defined as design choices that benefit an online service by influencing users' actions. Such an influence can take the form of coercion, nudging, deception, but in general, it may be considered as a form of manipulation. So for example, dark patterns can consist in interface elements, drive users to consent to privacy-invasive features. And I think that very paradigmatic example is cookie banners, or how certain cookie banners are designed. Or also other dark patterns make it overly difficult to withdraw from the subscription to a service. Thereby they cause privacy harm, financial harm. So now, why are we tackling dark patterns today? Why are they worrying? There are many reasons. One of them is that there is a growing number of studies demonstrating that they are practically omnipresent on digital services. According to certain estimations, they may be present on 90% of cookie banners in top UK websites. They are also present in 95% of the most popular apps on app stores. And the fact is that they work very well. So they effectively steer users' actions and online behaviors, often without users' awareness. So the problem here, of course, is also an infringement upon individuals' autonomy. And many of these dark patterns may be considered illegal according to data protection and consumer protection regimes. So today, we're going to try to answer many questions, probably too many, but some of them will be, how do we draw the line between persuasive design, which is considered a righteous business tactic, and inadmissible manipulation? So where is this line between the two? And also, what solutions can we devise? Should we focus on better legal protections? Should we focus on tougher enforcement of existing regulations? Or should we rather equip the user and foster the user's capacity to resist to certain dark patterns? Now, for example, just to mention why this question is important, at the University of Luxembourg, with my colleagues from the human-computer interaction team, we carried out some investigation to understand why these manipulative designs work. So we asked questions on whether users are aware of their existence, whether they're concerned about them, whether they can even recognize them when they see them, and whether they are likely to be influenced, even if they are aware, even if they are concerned, and even if they are capable of recognizing dark patterns. And our results show that individuals are well aware of the potential influence of online designs in their actions. They're also capable of recognizing them, although it really depends, because dark patterns can take many forms. So it really depends on whether they're visible or not. But also the results show that there may be a difference in age, meaning that younger people and people that are more educated are more capable of resisting dark patterns than others. So maybe there are certain persons that are more vulnerable than others to this kind of online manipulations. And also we found that people are able to protect themselves, but have very limited cognitive resources. So given the fact that this phenomenon seems to be pervasive in online environments, then other protections shall be applied. Other questions that we're trying to tackle, that we're going to try to tackle today, are what initiatives against dark patterns exist, why that worked, what kind of ethical design practices exist, and what are the challenges that are lying ahead. And maybe lastly, also, how might we establish a closer collaboration between regulators, consumer organizations, academia, and businesses? So I'm going now to start presenting the great panelists for today. And I'm going to introduce them one by one, and then I'm going to let them share some initial thought to frame today's discussion. First, I would like to introduce Ailo Ravna, who is a senior policy advisor at the Norwegian Consumer Council. a government-funded consumer rights organization that has written reports about dark patterns and data protection in digital platforms. You may have read Deceit by Design. And very recently about dark patterns and unfair commercial practices. It's called You Can Log Out, but You Can Never Leave. They have filed complaints against Google and Amazon for the company's use of dark patterns. Ailo, the floor is yours.
Thank you, Arianna, and thank you for having us on. First, I'd just like to say that as a consumer organization, of course, we represent the end user, who is normally the one who's going to be exposed to dark patterns. And we are, of course, all consumers. And from our own experiences, but also from our contact with consumers, we see that people are faced with dark patterns all the time, every day when they go online. Even if you, like you said, the cookie notice, where you have to click yes, or you have to go through a labyrinth of different kind of settings that you don't understand. Or if you want to purchase something online, you might be pushed into buying extra things you didn't want because you were nudged into doing so. So as you mentioned, Arianna, through the work that we've done, we have looked at how the major platforms such as Google and Amazon and also Facebook use dark patterns to nudge people into doing things that are, for example, privacy infringements. For example, turning on facial recognition, or as we filed a complaint against Google for, tricking consumers into accepting very comprehensive location data tracking. We filed a complaint against them for breaching the GDPR, because we believe that when you use dark patterns to make people give consent to something like that, that is not explicit, informed, and unambiguous consent, and therefore it is not compliant. As you mentioned with the cookie notices, you normally get the choice to accept, or you have, which is one click, or you have to click through, you have to understand what you're saying yes through, and you have to do that for every website, every app, every online service you encounter usually. And often, even if you do not accept and you refuse the cookies, then they'll just keep asking you every time. So obviously people are just gonna end up accepting, and then they are tracked, and that's obviously a privacy issue. You mentioned that we filed a complaint against Amazon, and we did that because when you subscribe to Amazon Prime, which is a premium membership, and which is, by the way, extremely easy to subscribe to. They even use dark patterns to trick you into becoming a paying subscriber. You'd have to click one button. But if you want to get out, you have to go through, I think, 7 different screens filled with patterns that shame you and warn you and try to get you not to quit. And obviously, for a consumer who just wants to use a service, you do not have the cognitive resources, you do not have the time or the attention to deal with all of that. So yeah, we believe that in addition to being unethical, a lot of these dark patterns are in fact illegal. And I think I'll stop there. Thank you.
So thank you, Ailo. Indeed, thank you also for giving practical examples of what dark patterns are. With this, I would like to go on with Anne-Jel Hoelen, who is a senior legal counsel at the Netherlands Authority for Consumers and Markets, the ACM. She's also a frequent speaker and guest lecturer in consumer and information law. ACM is an independent regulator that champions the rights of consumers and businesses and is charged with competition oversight, sector-specific regulation of several sectors, enforcement of consumer protection laws. And one of the main reasons also why she's here is that in 2020, the ACM published the guidelines on the protection of the online consumers. Here, boundaries of online persuasion, and the related rules of thumb for online platforms. So Anne-Jel, I will leave you the floor if you want to say a couple of words about this.
I will make the, thank you so much, Arianna, and I will make the link to consumer protection. So consumer protection is intended to connect the imbalance power that exists between the professional party offering products on one side and the consumer on the other side. It's also very much about consumer trust. So this is essential for well-functioning markets. And consumer law does this, amongst other things, by imposing requirements on transparency and by prohibiting misleading and aggressive commercial practices. So businesses must also meet certain professional standards and act in line with, honest market practices or the principle of good faith in the trader's field of activity. Well, all of this is reflected, for example, in the principle-based and technology-neutral rules of unfair commercial practices, and they are already enforced from 2008, so that's quite some time. But what do we see in practice? Well, since the existence of online services, companies have influenced consumers to induce certain behavior, including purchasing decisions and, purchasing services, for example, against unfair terms and conditions. We see that businesses increasingly know how to effectively use insights from communication and behavioral science, because they can test what is effective and what's not. So user interface and user experience designers use these insights in their designs and turn the insights into something that works in practice. Data analysts check if it's truly effective and use the results in a feedback loop. So you can imagine putting all this together, that consumers are more and more and more intensely influenced. And we are talking today about all these behavioral insights, all these dark patterns, nudges that just go overboard. So we combined what's already there in regulation about unfair commercial practice, connected these with examples of nudging and, when they go overboard, dark patterns, and drafted guidelines. Also, we connected this with insights of data analytics and presented these guidelines for businesses, but also for consumer organizations and for consumers as well. And we added some extra rules of thumb, especially for providers of online platform services. Any doubt about which rules should be followed online, there's no doubt anymore, I think, and they all can, comply with the law, and they should, of course. Thank you.
Thanks so much, Anne-Jel, indeed. And maybe we're going to get a little bit more in depth about this later. But first, I would like also to kind of finish the round of supervisory authorities. And I'm very happy to welcome today also Estelle Hary, who is a designer at the LINC, which is the Innovation and Foresight Laboratory of the French Data Protection Authority, the CNIL. She works on a range of projects, including digital products and services, to help professionals in their compliance processes, and also to support citizens to better control them. She focuses on the inclusion of design aspects and approaches within the regulatory framework. There is a platform, the Data and Design Platform. If you don't know it, check it out. And also she does experimental projects on issues related to data protection. Estelle, welcome.
Thank you very much, Arianna, for the invitation and also the introduction. So I guess seeing a designer or a term design linked to GDPR is kind of a weird association. So I guess when you hear interaction design, service design, or product design, it's not really the first kind of term that comes to mind when you think of GDPR or data protection. This said, at the CNIL, we've explored the link and the relation between design and data protection for quite some time now, I would say 6 years. And our conclusion, that, well, actually we've published 2 years ago and a report on this specific link between design and data protection. And basically our conclusion there is that the way an interface or a user experience is made has a huge impact on the ability of individuals to understand how their data are processed and also have control over their data, of course. So the thing is also that what we see online, all the interface we see online, either the data protection is not thought through and it's not included in the user experience or the interfaces, or they are basically using dark patterns that nudges the user so that she has a behavior that negatively impact her privacy. So basically, also what we've observed is that from the data protection or regulatory authorities in general, and also among lawyers, basically they're ill-equipped when it comes to design expertise and design knowledge. And then on the other hand, designers are not already aware of the regulations and the legal frameworks, and they don't feel legitimate to use it or include it in their design work. So basically there is some kind of gap there, and so the work we've started 2 years ago is trying to bridge this gap and those two kind of professionals in order for them to work together basically and to create services and products that include legal requirements reading the user experience and in the core of the service and product and of its interface. And so as Arianna has just said, we've launched a platform that's called Data and Design. It's accessible online at design.cnil.fr, I guess. And through this platform, we're really aiming to create this link between designers and lawyers. So on one hand, we explain some of the GDPR principles that are quite relevant in that regard, in that specific context. So there is information, consent, and rights. And then we also, in parallel, we also host workshops in which most of the time we have designers, lawyers, product owners, tech people coming together and trying to tackle some data protection issue. So for example, we've worked on including information throughout a user experience on an e-commerce website. We've worked also on the privacy notice, for example. And we were planning, because of the pandemic, we had to slow down a bit on this workshop hosting, but basically we also plan to work on consent and, for example, chatbots as well. And all this material that is created throughout this workshop, they are made available online afterward under case studies and resources that are available for everyone to use.
Perfect. Thank you so much, Estelle. We're going also to disentangle a little bit also the work that you've been doing during these workshops. But first, I would also like to present one of the other panelists for today, who is Geoffrey Delcroix, who is a head of legal innovation at Ubisoft. She's a leading creator, publisher, and distributor of interactive entertainment services. So you may know, for example, famous video games brands like Assassin's Creed, Far Cry, Rabbids, Just Dance, and many others. And Geoffrey is a professional futurist and innovation manager. On the privacy side, before joining Ubisoft in 2019, he co-founded The Link, so the laboratory that we're speaking about it now, of the CNIL, and worked there for several years. So, Geoffrey, you represent the corporate perspective, I would say, on this panel. What would you like to share with us?
Hello, everyone. Thank you, Arianna, for this introduction, and thank you for having me in this panel. Yeah, I represent the corporate world, right? It's very easy for me to talk just after Estelle, because as you said, I worked at CNIL and with her on this topic before joining Ubisoft. And can I say, I arrived with that in my backpack when I joined Ubisoft as head of legal innovation. So I'm working inside the legal department of Ubisoft, and our mission is to explore new ways of working for the legal department and try to gather skills and experiences that are different from the core legal ones. And when we arrived, we decided to try to obviously put more technologies, legal technologies, automation in our jobs. That's very common in the legal innovation space. But we try to really focus on connecting the job of the lawyers, not only on the compliance and legal side, but really to connect it to the business side of the company and to what we are trying to create as experiences for the users, well, the players of the video games. In my team, there is a designer, a developer, and right at the beginning, we tried to have this idea to work with people that are, for example, designers in our business teams. And on the privacy side, so I arrived with this background from CNIL, and we wanted to, with the data protection officers, wanted to work on not only on the compliance side of the privacy policy and all the tools that we're making available, when really trying to go to the extra mile. And that's what we decided to do in trying to incorporate a legal design approach in the creation of a new version of our privacy policy. So this is still an ongoing effort. I'm not going to tell you that everything is already done and everything is perfect. But I think what's interesting is that I'm going to just jump on what you said at the beginning, this idea, where do we draw the line? And I hope that you know quite unusual experience right here, because having a legal innovation team inside the legal department is not something that is very common for the moment. There's two things that are interesting. First, video game industry is quite uniquely positioned around this topic, because video game industry create very immersive experiences for millions of people, and player can come to enjoy the effect of some kind of what people call voluntary suspension of disbelief. You can fly, you can be a Viking warrior, you can live 1,000 lives, and this year showed that this can have a positive impact on a lot of people in their daily life. And so there are a lot of patterns in game design that uses the perception of people, and that's not something that is bad. You just want to bring to life the world that we create so that people are immersed in it. So we have a lot of people that are really, really experienced in this idea of working around perceptions and the way people react to an experience. And we try to work with them, for example, with the user research lab. Maybe we can talk about that a bit more later. And on the other side, on the legal side, on this topic of where do we draw the line, what we really want to try to do is say, okay, we're not just going to focus on compliance and the legal side of privacy policy, GDPR, and things like that, but really go the extra mile and try to understand how really people are going to react to what we are creating. So, for example, working on the clear language of our privacy policy, that's not really going to naturally enhance the compliance of the privacy policy, but is going to make it more usable, easy to understand. So working on the structure of the information, using question style sections instead of very legal wording sections. We're really trying to test that, and for that maybe you can again explain a bit more later, but we organize workshops internally, and what we've done is that trying to work not only with lawyers, but bring designers, people from our customer supports, people from the people that are working on the player experience and the player's account, so that you can help us integrate all this legal stuff inside the global player's experience.
Thank you, Geoffrey. I think you're perfectly right. I think that what is coming up from all of you is this necessity for interdisciplinary work. Otherwise, we're not going to make it. And now it's my pleasure to Frederik Zuiderveen Borgesius, who is a professor of ICT and law at the iHub, which is an interdisciplinary institute at the University of Nijmegen in the Netherlands, where he teaches law to computer science students. So Frederik, I'm very happy to have you here. And I would like to, yes, do you have something to share with us? Would you like to react to the other speakers?
Thank you very much. Super interesting remarks of everybody. I wanted to suggest two things that policymakers and regulators can do. Like, it's great to see that the CNIL and the ACM, Anne-Jel here, are thinking about how to apply current rules, such as the open norms of the GDPR and of consumer law, to regulate dark patterns. And indeed, with some, sometimes it's quite obvious that certain dark patterns violate some rules. Sometimes we have to be more creative interpreting existing rules, but that legal scholars and regulators are used to, so that is not a problem. So indeed, I think enforce what we have in Europe. We can be very happy in Europe with a level of data protection and a level of consumer protection law that many regions in the world can only dream of. So that is strategy one. But strategy two, I think that we also need to think through whether we need perhaps more specific rules to regulate dark patterns. And I have some ideas about how you could do that, but I'll postpone that until later, because I don't want to take the floor too long now. Thank you.
Perfect, Frederik. So thank you so much. Perhaps we can already start with a couple of questions. And maybe I would start from Anne-Jel, and I would ask, so the very title of your guidelines are this kind of boundary of online persuasion. So my question is very direct, is, so where does the boundary between persuasion and manipulation lies? How did you establish this in the guidelines, and can you make even probably specific examples of what you have been describing in the guidelines?
Excuse me. So to start with, the boundaries that are set in the Unfair Commercial Practices Directive are very clear in relation to if it's not on the blacklist of the Unfair Commercial Practices Directive, then the test is, well, can this make the average consumer try to make a decision on a transaction that he otherwise wouldn't have made. So this is a transactional decision test, and this test is applied in relation to misleading practices as well as aggressive practices. So and then you have to apply the average consumer test. So this average consumer has a quite high standard. This is a reasonable, well-informed consumer, and who is reasonably observant and also circumspect. Also, you have to take certain aspects and in consideration. Social aspects, cultural aspects, and linguistic factors. This is, so I already talked about misleading practices, and next to this you have aggressive practices. And for example, this is the boundaries are met if there is coercion, and together with again the impact on a consumer to make a transaction that he otherwise wouldn't have made. So this is the tests that are in the Unfair Commercial Practices Directive, and we combined these practices with the dark patterns that we saw, and we measured the effect of the dark patterns and assess the impact that it would make on a transactional decision of this average consumer. And of course, there's also a correction of the average consumer, and that is the consumers that are particularly vulnerable because of their age, maybe, and because of a handicap, for example, or when a trader knows that the trade practices he applies has a special effect on these consumers. Then you have to take this average consumer into consideration. So all of this, we try to fit in these guidelines, and therefore, I think we applied a lot of examples in these guidelines to make it clear how this effect is assessed in practice.
Perfect, thanks. And perhaps, Frederik, you would like to give an opinion, let's say a view from more data protection perspective. But before doing this, so I would invite you to do that, but I would also like to start reading some questions that are starting to appear in the chat, and maybe we can combine, let's say, this question with other questions. So one of the question is, behavioral design affects the agency of individuals beyond consumer or data protection because it leverages social, language, psychological cues to trigger certain behaviors in users. And indeed, you're also talking about, for example, harms, not only financial harms, not only privacy harms, you're talking about harms in attention, behavioral addiction. So it's indeed much, much broad. So the question from the audience is, how do panelists think that these issues can be tackled? Should we coordinate more branches of the law, antitrust, data protection, consumer protection? Should we use a human rights approach? Should we use another approach? Frederik, maybe you would like to comment on that?
Thank you. So your first question was, to what extent can the GDPR help? Because indeed, as I said earlier, let's start with what we have, like the GDPR and consumer protection law. The GDPR has, regarding privacy choices, the quite strict requirements for valid consent and quite strict requirements on transparency. So you could definitely argue that doing design tricks that hide the real meaning of a consent request, for instance, that goes to the general idea, that goes against the general idea of fairness and transparency. And you could also say that in the GDPR, the of privacy by design, at least the spirit of that idea goes against, so would argue against the use of dark patterns. However, that is pushing a bit against the rules to make them apply here. But let's try that as long as we don't have additional rules. Then somebody asked in the chat, somebody from the audience, should different fields of law cooperate? Yes, definitely, indeed. Data protection authorities and consumer authorities and competition law authorities should cooperate, because none of these fields can solve the problems on its own. And on top, I think that we need to explore whether, while we and regulators apply current law, I think we also should explore whether additional rules are maybe needed. And one option how that could be approached is put down a general open norm, something like unfair designs are banned. And admittedly, that is then a rather vague rule. But if we come across a really scandalous dark pattern, then there shouldn't be too much discussion that violates the open rule. And then it could be coupled with a list of suspicious examples. So you could say practices that are assumed to be an unfair design unless the company proves otherwise. And there you could for instance, imagine rules such as it is prohibited to make an opt-in button look much more appealing than an opt-out button. And then the company can still give counter evidence, but you can assume this is unfair. And then after a few years with court cases, then we can make that list longer all the time. And with enforcement by the CNIL and the ACM and other European regulators, we can keep on extending that list, but you still give some room, wiggle room, because it's an assumption of, it's not a full ban, but an assumption of unfair design. So I think that could be a way to go for the future.
Thanks. Talking about blacklisting and maybe even whitelisting, we have a question from the audience, and it's something that it's probably for Estelle and Ailo, but I think it would be interesting also to hear Geoffrey view about this. And the question is, so do you think it would be meaningful to develop and disseminate certain design patterns that prioritize privacy and autonomy concerns with the hope of creating a more user-friendly and ethically minded digital environment, which is more or less also, for example, what the CNIL is doing to a certain extent? Or would this approach prove too rigid for the various kinds of websites and apps, and each have the legal context, but it's not all about legal context, right? So we're talking about, so we have Ubisoft on board, maybe it's a completely different industry than another industry, right? So I would prefer to have invite Ailo maybe to react on this, but Geoffrey next. Estelle or Ailo, who would like to take it? Estelle.
Okay. So I think that's a good question, and as you said, Arianna, that's true that we are trying to do a bit of this work through the Data and Design Initiative. Actually, I think what's important is to make the designers, and then I already mean the term in a general way, so engineers, designers, lawyers, all the people working on a website, on a service, product, make them understand that they have to think about the regulations that apply to their product, not only to be compliant, but also in order to create some trust with their users or consumers. So basically, that's a bit of a feedback we got from the workshops we made, but many people with an entrepreneur, if I can say, background, they kind of understand what we are working on in a way that they can sell their product in a way that create trust with their users. So basically, being clear and transparent on how the data are processed is likely to create a trust link between the service and the user. And so once you have this trust, it's likely that the person will stay with this service or product. So there is this interest, I would say, as well. And so to answer a bit more to the question, I would definitely say that giving good ways, giving to see good practice, let's say, it's important. But I think the copy-paste approach doesn't really work. And it's also important to help the designers in general meaning to be able to think by themselves and do this good design by themselves, basically.
Ailo, would you like to build on top of that?
Sure, yeah. I think it's an interesting suggestion. And I attended a panel earlier today that was about the possibility of standardizing consent flows, for example, which I think it's not a bad idea, obviously, because if you have a ethically designed consent flow that's more standardized, then it's easier for the consumer to know what they're doing when they're clicking that button and what they're doing when they're clicking that button. But at least when it comes to things such as cookie banners and these kind of issues of data protection and consent, I also have a concern that even if you distribute ethical design patterns that are standardized, if the processing is underlying that consent flow is unethical or illegal, you're basically just putting lipstick on a pig, as far as I see it. So, for example, all these attempts at creating easy to navigate transparency, like concept management platforms that we see a lot of, where they can say, oh, we're so transparent and we made it so easy for the consumer. And then you still end up consenting to data processing by third parties that you've never heard of, used in ways that you could never predict. And I think in those cases, I think even if you make a nice framework for it, the solution is not to make a more ethical design, but to just stop doing that kind of processing in the first place. But in other contexts, for example, say video games, and I know that, for example, mobile gaming, freemium games have a lot of these dark patterns to make especially young people spend a lot of money. I think maybe something like a more ethical framework to put to kind of push companies against this might be a good idea. But of course, the financial incentive will be to sell more of microtransactions, for example. So you always have to push against that incentive. So yeah, I don't know if that answered the question, but those are my thoughts anyway.
Perfect, thank you. And Geoffrey, would you like to react to these statements?
Sure. I think it's very interesting when we talk about, let's start with what we have. This idea is that if everybody just aim with for the minimum legal requirement, everything is going to end nearly identical, on all services and websites. So at one point we need to try to point out best-in-class solutions. And I think that we need to try to find, bright patterns, because sometimes there are dark patterns, but sometimes there can be things that are designed to be more transparent or give more agency to the user. It's not that easy, but I think that we should try to find the two sides of the coin and not just focus on the dark ones. One thing I think is interesting in what was just said is that standardizing things can be useful, because familiarity can matter in online experiences, because people just can't learn new ways to interact with services every second. So some kind of standardization could be good. But I think that in the end, what's important is that you try to find something that is consistent with your business model, the experience and the relation that you have with the user. And that's what we're trying to do, as I explained, when we're working with our colleagues from the customer support or player experience support, or when we're working with our user research lab. We're trying to understand what is really in the mind of the players of our games, to try to focus our legal experience more in something that is more understandable for them.
Perfect. But indeed, you mentioned there's the user research lab with whom the legal team does a lot of research as well. So it's user research, not only about the experience of the game, but it's also the experience of the law, let's say, inside of the many games. However, there may be many other companies that do not have the resources to probably to also to resort to a user lab, although it would be great. And then in those cases, for example, standards or at least blacklist and whitelist is something that may be looked upon because it's just easier to implement. Now, talking about, so sorry, I'm also reading questions at the same time, and I see that there is a question about about bright patterns and dark patterns. Frederik, there is a question for you, which goes like this. So in a recent paper that you wrote, you argue that even bright patterns that were there to contrast dark patterns, they do not, or at least they do act upon an unreflective default behavior, which means that users anyway feel kind of, they kind of feel like a lack of control anyway. So this agency, this autonomy. The question is, how would a neutral design pattern work instead? Do you have any thoughts about this?
Yeah, that reminds a bit of, thank you for your question, good point. It reminds a bit of what they call in a nudging theory, what is it, forced choice or something. Because if you give people a choice, you could make an opt-out system, what companies generally prefer if they want to track us online. They try to design it in a way that we have to do something not to be tracked. You can make an opt-in system with, if it happens with fair design, then it would be a nudge towards privacy. For instance, Sunstein and Taylor, who have kind of invented the phrase nudging, they also talk about, I don't remember the exact phrase. It's sort of, prompted choice. That is it. So that you present without pre-selected buttons, etc. So you present people with a really neutral choice. So it is possible. However, I fully agree with what Ailo said. In many cases, the solution is not putting lipstick on a choice. In many cases, the solution should be not bother people with choices at all. So to stick with the example of cookie banners, we should just not be asked for disproportionate tracking. And there's even in-between solutions. Actually, there is a proposal, which it's embarrassing because nothing is happening for a few years now, but there is a proposal in Brussels for an e-privacy regulation. And in the version of the European Parliament, it says, I'm summarizing here, that a system should be in place that all internet companies should follow, where you check in your browser or in the operating system of your phone once, I don't want to be tracked. And it also says companies should not, or at least it should say, companies should not nag for consent more often than, let's say, 2 times a year. And the proposal includes a ban on take it or leave it choices and cookie walls. And like that, you basically limit the number of times a person is asked for consent. You would have an even more limiting effect, of course, if you would just ban online tracking. But let's start perhaps with a bit of softer rules. And in many cases, I think the solution is ensure that the data subject or the consumer has less choices to make, not make choices better and easier, just protect people better.
Indeed. So this question, let's say, so there are different views, but this question of should we protect users better? Should we enforce the laws that we have better and that's it? Or should we also rather try to act on users' ability to resist online manipulation? So the problem is that with enforcing the laws, then maybe we always come a bit too late, especially if we see the fact that there is, that these dark patterns are very pervasive all over the world. And this is why one of the solutions that has been proposed is also, why don't we ask companies, or at least big tech companies, to let's say to complement, so to offer for preemptive scrutiny their UIs, for example, so their interfaces, before even publishing them, so that there are maybe different alternatives. And some of them can be say, okay, these can go, these other is a no-go. This can be a solution. Whereas there are others saying yes, but we since online manipulation online is not only about manipulative designs, but it's also about much more manipulation. We're talking about misinformation. We're talking about online scams. We're talking about, as Anne-Jel righteously said before, the online trust ecosystem, the trustworthy ecosystem, which is much broader. So should we rather focus at least some of our energies to try to train people to be a bit more resistant and more cognizant when they are navigating online? So on the one hand, there is this view of empowering users. On the other hand, there is this view of protecting. I don't think that they are necessarily one against the other. But I'm wondering what kind of tools should we give to enforcement, for example, to have it a bit more a tougher enforcement or a more rapid enforcement? What do you think? Is there anybody that would like to take the question? You can write it me in the chat. Mm-hmm. Which way should we go? Tougher enforcement, should we? Frederik first, and then I will go with Anne-Jel and then Geoffrey.
I think definitely that we should not focus too much on educating the general public that uses the internet, because that would put an unfair burden on their shoulders. And we don't do it in other sections in the society either. We don't expect consumers to be able to judge whether certain ingredients are safe in food, etc. When you walk into a supermarket, you know that that nothing is poisonous. And if you read the fine print, it will never say there might be bits of glass in there or something. You just know that only pretty much safe food is on the market. It's bad enough that we have to read all the small print if we don't want to become too fat. But at least the poisonous stuff is not on the market. And I think, and just like with cars, you can't really buy a completely unsafe first-hand car on the market. It seems that policymakers give too much responsibility to the individual on the internet, and it is often an unfair burden that we're putting on people's shoulders. So yes, empowerment is important and protection is also important, both, but I think we should focus much more on protecting people rather than on educating them.
Thanks. Let's make also Anne-Jel, for example, you wanted to react on this?
Yes, well, I agree with Frederik. But speaking from a consumer authority, we also believe in empowering consumers. So there are these the more darker patterns that consumers can be a little bit more aware that what happens online and what happens with their data and how they're influenced. But I think on the other hand, it's just like with misleading advertising. We know since such a long time by regulation that it works, advertising works and misleading advertising works, and we really should protect consumers against this. And this is why we drafted these guidelines. And for 2021, we said, well, and now we've written everything down very clear again, and we will enforce it in 2021. As we did before, because all these dark patterns, it's quite a new name, but it's not new. I mean, it's as old as well, misleading advertising, to be honest.
Thank you. Thank you, Anne-Jel. Indeed, there are a lot of links there, and it's not a new phenomenon. Maybe it has new forms, but it's not a new phenomenon indeed. And Geoffrey, I think you also had raised your hand. Maybe you wanted to add something?
Just something very, very short, small point. I think that, as someone said, it's very important to remember always that being a user of a service is not a full-time job. We're not going to make people data protection and privacy experts, even if, well, some people may like that. It's going to be very difficult. And I just wanted to tell you something. When we made this user research around your new privacy policy, one of the feedback that we get from the people that were real people, users that were shown the new text. It was around the definition of personal data. And everybody that works in this area knows that this is always a very complicated question, because it's very obvious what is personal data, and absolutely not obvious at all. And in fact, we had a lot of feedbacks from the people that were interviewed by your research app around the idea that the definition of personal data that we tried to use, that was, we believe, quite usual and explicit, was not very well understood and created a lot of people were asking, I'm not sure I understood well what they are talking about. And I think it's important to remember that we are working on around topics that a lot of people, it's very complicated to explain it. So I agree that we shouldn't focus always on trying to give people a lot of information about personal data.
Yes, thank you. And I see that also Ailo perhaps would like to add something on top of this.
Yeah, thanks. And I agree completely what was said before, and with what Frederik said about the burden here. There's a huge power and information asymmetry between the user and, for example, a platform like Google that has behavioral scientists and hundreds or thousands of designers, and they do continuous A/B testing on consumers. So there's obviously, I think we cannot place this burden on the user. And to the point about having to keep the trust of the user, I think that applies in a case where, for example, I discover that a web shop tricked me into buying something I didn't want. Then I'll get annoyed and I'll think maybe I don't want to purchase from them again. But if the harm is invisible, such as a data protection harm, I'll probably never know that I was manipulated. So the incentive to switch doesn't work. And two, if the platform, for example, is a dominant actor and doesn't have any real competition, I can't really go to the competitor because I felt like I was tricked. So I think in that sense, dark patterns may also be, in some cases, an abuse of dominance, I think. And just one final point to what was said about the privacy policies and everything. And I'll say, like, I've played hundreds of video games in my life, in my personal life, and Ubisoft games as well. And I've never once, even though I work with this, I've never once read the privacy policy of a video game. And if I download Assassin's Creed, I want to play Assassin's Creed and be a Viking, I don't expect the data to be shared or to be profiled. So even though I understand that transparency is important, I think for the actual user, the end user, you just have to expect that you're not being kind of exploited by the company. Thank you.
So I think that we're rapidly coming to the end of the panel. Maybe I really wanted to read a couple of comments coming from the audience. And there is some mentioning the fact that the problem is the business model. So how can we, so to what extent is the problem the shift in business models? There are freemium business models, have very strong incentives to manipulate users in engaging regular microtransactions. So of course, it's also a problem of economic incentives. Would anybody from the panel would like to comment on this?
Frederik here, the audience member is completely right, of course.
Frederik?
Yes, the audience member is completely right, of course. It are the business models that push companies to behave like that. And what is even more tragic, if, let's say, Ubisoft is well-meaning, but all the other companies are not well-meaning and use dark patterns and collect more data and can exploit more data for better targeted advertising, then it becomes harder and harder for Ubisoft and other well-meaning companies to compete. So even if some companies are well-meaning, sadly, tragically, in a market, then they are often passed in profit, etc., by other companies who are less ethical. And that is where law has to step in, because only if the law requires other companies also to design fairly, then one company knows that there won't be competition will not misuse their ethical standard.
And maybe, so before we conclude, let's say, this panel, I would like to ask you something. In another conference as well on dark patterns, I heard a colleague of Anne-Jel from ACM talking about what are the solutions, right? So as we were mentioning, it's a very complex topic. There are so many interests at play that we cannot just say, this is the solution, that's it, and we should go with this option. What I heard is that the perfect recipe, let's say, to solve this issue is a mix of education of users, but also especially of businesses, scary case law, research on dark patterns effects, and also closer collaboration between academia, enforcement, business, and legislators. And maybe someone would like to comment on this and say, Anne-Jel.
Yes, I think that drafting these guidelines was an example of close cooperation between ACM, who we asked the people from science and experts, among which Frederik, to comment on the guidelines. And I think the final guidelines is a result of our assessment of the law in combination with dark patterns, together with the criticism on it from science and also businesses. And I think this is very helpful in the end to present this product to, for example, user interface designers, user experience designers, and providers of online services.
Okay, so maybe let's make an experiment. If we have to have this panel in 5 years from now, what do you think have happened by then? Let's say, so 2026. Where will we be?
Well,
Anne-Jel.
I think there is a problem with the freemium model. There is on the blacklist in the Unfair Commercial Practices Directive, there is something that says, well, you cannot call something free when it's not really free, when you have to pay something else than having the product sent to you, for example. I think this, you see this in consumer law more and more, more and more it are the services that are for free leveled with the services that are paid for. And I'm really curious if freemium models won't be blacklisted in the future.
Okay, so unfortunately, we couldn't tackle all the questions for today, and we're rapidly approaching the end. I would like from each of you maybe a concluding remark, one sentence, very quick. Thanks, and maybe I will start with Frederik.
Thank you for the great panel. One reason for optimism is that at least regulators and academics are not too late in, it is not that we've waited 15 years before we started thinking about dark patterns. Of course, companies are years in advance of us, but it's a good sign that you panel organizers and you NGOs and you regulators are already thinking about this. And thanks for the great questions from the audience.
Thank you, Frederik. So perhaps, Estelle, would you like to add something?
Well, I would say that this issue needs a collective work from regulatory authorities, academics, civil societies, and companies who wants to work on it. And also, I think in the next years, I guess more and more regulatory authorities will give decisions and create opinions on this. To be continued, basically.
And perhaps, Ailo, would you also like to share a concluding remark?
Yeah, thank you for the great panel, and I think.
You did.
Okay, is it working now? Thank you for the great panel, and
Yes, yes.
yeah. Thank you for the great panel, and I think this is just still the early stage of this work, and I hope that we'll be seeing more enforcement on this from the protection authorities and consumer authorities across Europe in order to set the limits of what you're allowed to do.
Thank you. Maybe a super short comment from Geoffrey as well.
Okay, I'm just going to make it super short. Thanks everyone, and I just want to finish by saying that what was interesting for us is really trying to work with people that don't inside the company don't really know and maybe don't really like legal issues. But it's, for example, our user research lab say, oh, it's interesting to do some user research on legal stuff. It's different from what we do around video games. So sometimes you can create some curiosity and involve people that can help us do a better job.
Perfect. So, Anne-Jel, would you like just to add something very short?
Very short. I think the future is in cooperation between consumer protection authorities, data protection authorities, and as well competition authorities as well. But of course, with input from science and businesses. So yeah, cooperation is the key word, and I hope to continue with this in 2021.
So thank you so much for being here today. Thank you so much for the audience and for the questions. I would also like to thank the CVD organizers, the technical staff that made this possible. As we know, we didn't end, let's say, the discussion about the patents, but you can find some of us also in Gathertown later if you want to find us in front of Salle 4, or you can just look for our names online. So thank you so much. Have a great continuation of the conference.